Hey everybody, welcome to Thursday night here in the Consumer Warrior YouTube channel. John Skiba here. I'm an attorney in the state of Arizona, and I help people who are dealing with serious debt problems. Glad to be back after a week off, maybe 2 weeks off. I was on vacation. I got injured on vacation. I was rock climbing. Actually, I hit it on a counter. So I'm here, bandage on, everything ready to go. Again, my name is John Skiba. I'm a bankruptcy attorney and a consumer, I guess I would call you consumer protection attorney. I represent people being sued by creditors here in this great state of Arizona. I do miss a few weeks here and there during the summer when we're on family vacations, and it's definitely summer here in Arizona. Yesterday, when I got in my car to go home, it was a balmy 116 degrees here in the great Phoenix area. But glad to be back. Glad to be on this live stream. Go over any questions that you have. Talk about all things debt related. Again, bankruptcy, debt collection lawsuits, whatever it is. My weekly disclaimer, I am a licensed attorney. I've been doing this for about 22 years, but I am not licensed anywhere else, only here in Arizona. You shouldn't take this as legal advice. Doesn't create any type of attorney-client relationship. Just some guy talking on YouTube, so take it for what it is worth. So how we do this each and every week, if you have a question, whether you're watching on YouTube, Twitter, X, Facebook, go ahead and put a comment in either a comment or in the chat section on YouTube. Put a question there. I'll put it up on the screen and we'll talk about it. Again, I think my whole goal here is to kind of point you in the right direction of some things and resources that can help you deal with serious debt problems. I do want to thank our weekly sponsor of this live stream, Solo. I was actually just on their YouTube channel yesterday with George, their founder, answering questions like this. But I put a link in there. Click on there and look at some of the cool products and technology that they have to help you deal with debt problems, settle debts, respond in debt collection lawsuits, all kinds of cool resources. So, and I also put a link in the chat section. If you're in the state of Arizona and you're looking to file for bankruptcy or you need help with the debt collection lawsuit, feel free to check on that. You can set up a consultation. You'll talk with me, and I can help point you in the right direction. All right, let's start off with some of the comments that I was able to pull from the channel that I think can be of help. This person, MK006THST, asked a question related to a debt collection lawsuit, saying, can a default judgment be appealed? Now, I can tell you that over 95% of debt collection lawsuits end up in a default, meaning that you get served with a complaint and summons, you don't file a response, and so the court enters a default judgment against you. So the question is, can that be appealed? And it's a little bit of a nuanced answer, but just as kind of a straightforward answer, the answer is no. Default judgments, you cannot appeal a default judgment. You can do a couple things, though. One is you could file a motion to vacate the default judgment. That's not an appeal. You're actually going back to the court and saying, hey, judge, I want you to set aside that default that you entered, but you have to have a legal basis for it. I can tell you the number one thing that I see as far as a legal basis to get a default judgment set aside is if they didn't serve you correctly. Now, in most jurisdictions, in order for them to serve you with a complaint and the summons, to really start that clock ticking for you to respond to it, a process server, a constable, sheriff, whatever they do in your jurisdiction, has to bring it by and put a copy of it in your hand. Now, usually the rules, and it's Rule 4 in the Rules of Civil Procedure in most states. Rule 4 will talk about exactly what has to be done in your particular area. But in most jurisdictions like Arizona, where I practice, what they have to do is they have to serve you at your residence or someone who lives with you. They can't serve your friend who's just over there to watch the game on a Sunday afternoon. They can't serve you at an old address. Unless they get permission from the court, they can't just drop it off in the mail. They've got to get permission to do that. So if they don't do that first step correctly, then you can go in, file a motion to vacate it, say, hey, judge, they didn't give me proper notice before they got this default judgment. And if you have proof that they didn't do that, you're going to be able to get that set aside and be able to deal with it and file an answer or try to resolve it however you want to pursue it. So hopefully that's helpful if you do have a default, but no, you can't appeal it directly. I can tell you what you can appeal. If you file a motion to vacate the default judgment and the court denies that, You can actually appeal the denial of your motion to vacate, but no, you cannot appeal a default judgment. All right, Sarah-U8Q7L says, "Hi, sir. I just was sued by Wells Fargo for $7,000 credit card debt. Should I answer the summons or just show up at the hearing date?" Sarah, if you're a regular on this channel, you know my answer here. You should always respond, and you should always show up. So you should do both. Now, there are a few jurisdictions where they just send you out a complaint and a summons, and it has a date and says show up. Most jurisdictions, though, you're going to have to file a written answer to the complaint. Now, the answer is a pretty simple document. Really, what they're wanting you to do is respond paragraph by paragraph to the allegations in the complaint, or sometimes it's called a petition. The reason is really, here's how to look at it, is the complaint is the plaintiff saying, hey, judge, here's all of our allegations against this particular defendant. The judge is saying, okay, great, defendant, how do you respond to each of these allegations? Do you admit what they're saying? Do you deny what they're saying? Do you need more information before you can really admit or deny? Basically, the court wants to see, do we have a dispute? Do the parties agree on everything? If so, the court will just enter judgment. But if there's a dispute, that's what the court's there for. The judge is the umpire who's there to say, okay, you're liable or you're not liable on the allegations in the complaint. So my recommendation, and it'll say this in the summons. If you look at the summons, it'll say that you've got to respond. It'll usually tell you you've got 20 days, 30 days, 14 days, whatever it is. You need to file an answer timely to make sure that you don't run into any problems there. Now, if it has a hearing date, you need to show up there as well. Most debt collection lawsuits are lost because people don't participate. They're not, the consumer, the defendant is not engaged in the process. You need to make sure that you are engaged if you want to get the best possible outcome. All right, and then this one is actually by, looks like PuttyCat00, says, I don't care what these YouTubers claim. You cannot get away from your debt. You have three options: to settle, to file bankruptcy, or do nothing, and they'll win and collect by taking your assets or have your paycheck garnished. Well, PuttyCat00, I tend to agree with you. I guess I'm a YouTuber. I'm a YouTuber / lawyer. So I would give you four options. You've given us three. I mean, your three are you can settle it. Absolutely. You can offer something less than what's owed on it. You can file bankruptcy. Absolutely. That's your nuclear option. That's where you pull the grenade, throw it in there. You can get rid of it completely. Or you can do nothing, and then they'll win, and they're going to garnish you. I guess the fourth thing I would give is you can also fight it. You know, when it comes to junk debt buyers, there are strong defenses to these cases. And it's important, though, to understand. I can tell you that most lawsuits settle. Even if you have a really strong defense, there's always uncertainty when you go to trial. It's also expensive to go to trial. And it takes a long time. Here in Arizona, where I practice, even if you're in the justice court where it's $10,000 or less, or if the amount in dispute is under 10 grand, that's where it's going to be filed. If it's under $10,000, even in a case like that, which is a relatively small amount for a lawsuit, it's going to take you almost a year to get a trial date. So this thing is just going to be in the background of your life over a year. To me, you know what, if you can get a good settlement, and that's the whole key here, is positioning the case so that you can get a good settlement. If you let it go to default, if you don't respond to it timely, then you lose all your leverage, and they're just going to want the full balance. But it's something, if you can file an answer and present some of your defenses, you might get a better overall settlement to make it be dealt with. So, all right, let's see here. We have Mr. Lowrider 3 says, so I've been having a debt collection for almost 6 years now. In the state I live, the statute of limitations is 6 years, which is coming up at the end of this year. My question here is, am I off the hook? So the statute of limitations is the amount of time a creditor has to file a lawsuit from the time that the account goes into default. So, and it's different from each state. The state that Mr. Lowrider 3 here says that it's 6 years. It's 6 years in Arizona as well. So, for example, here in Arizona, the account goes into default. If we're talking about a credit card, it really starts, the clock starts ticking on the statute of limitations when they could actually sue you. Now, once you go 30 days past due, technically they could sue you. Are they going to if you're 30 days late? No, but they could. And so that's when the clock will start ticking on that 6-year statute of limitations. So if a full 6 years goes by and they don't file a lawsuit, then they're going to be barred from being able to bring that lawsuit ever. You're going to be protected, or if they do bring the lawsuit, you'll have a really strong defense to get it thrown out, saying that the statute of limitations has expired. Now, it's important to know that's different than credit reporting. Negative information on your credit report can stay for up to 7 years. It's 7 years and a couple months before it's going to go away. So it can still, so it's possible for a debt to be outside the statute of limitations. They cannot sue you, but it's still on your credit report. They can also call you and ask you to voluntarily pay. Just because it's outside the statute doesn't mean they can't ask you to pay for it. It just means that they can't sue you for it. So in this situation, if it's at the end of the year, so we're recording this in June of 2025, if the 6 years runs by the end of the year, I would watch out. I would still be vigilant on this, because I have seen debt collectors who will file it 6 months before the statute of limitations expires. I've also seen it where they try to allege the statute of limitations does not start. The clock doesn't start running until 6 months after you stop making payments on it. I don't agree with that interpretation. I think that it starts when they could actually sue you. But they may be thinking, oh, the statute doesn't run until June of next year, when you're thinking it's December of this year. So something just to watch out for it there. Let's see here. AmpBoy42 says, is there ever a time if you win money after the bankruptcy that they will come after you to pay? So good question. And it depends on the chapter of bankruptcy you're in and where the money's coming from. So Chapter 7 bankruptcy, which overwhelmingly is what most cases are filed under. It's a relatively short process, takes about 4 or 5 months. The bankruptcy court is mostly concerned from the day your bankruptcy case gets filed, right at the beginning, backwards. That's where most of the focus is going to be as far as income and assets and transactions. And generally, if you, like in a case like this, if you win money, if you file Chapter 7 bankruptcy on June 1st, 2025, and then you win the lottery in, October, it's not going to be an issue. They're only concerned with your income from the date of filing backwards. There are a couple exceptions in the Chapter 7. One is if you become entitled to an inheritance within 6 months after the date you file. So within 180 days from the day that you file, if somebody passes away and you become entitled to an inheritance. And notice it's not if you receive an inheritance, it's if you become entitled to it. And usually you become entitled once the person who you're in their will, they pass away, you become entitled to it. Then you have to let the bankruptcy trustee know, and then they may require you to turn those funds over. So that's something to be careful with. In Arizona, where I practice, it also tax refunds. So again, cases I'm filing right now in June of 2025, they're going to have to provide copies of their 2025 tax returns when they're filed next spring. And if they're entitled to a refund, a portion of that may have to go to creditors. Now that's different from state to state. Some states have wild card exemptions. There's actually a new law in Arizona that's going to exempt out a lot of the tax refunds that we're seeing. It doesn't go into effect until September of this year. But that's another area where it may become an issue. So good questions there. So, all right. This person said, this is Ghost Tacos 1975. I'm filing Chapter 7 bankruptcy. Is it true in some cases you can keep one credit card? I get this question a lot. The answer is no. You're not, in the old days when I used to do this periodically, we would see that happen. But even if, I can tell you this. Let me back up. If you are filing for bankruptcy, the bankruptcy code requires that you disclose all assets or all assets and all debts. And so if you have a credit card, even one that you want to keep, you're required to disclose it. You disclose it, they're going to get notice. The terms and conditions of every credit card states that the filing of a bankruptcy is an act of default. They're going to cut the card off. Even if you have a zero balance, even if there's nothing owed, the card's going to get cut off. All of the big banks, all the big credit card companies, they get electronic notices of bankruptcy filings. They're going to see that. They're going to cut off the card. So the answer is no. You're not going to be able to keep any of your credit cards. And so you need to be able to plan accordingly. I know life is hard without a credit card. Contrary to what Dave Ramsey says all the time, and I'm a big David Ramsey proponent of his plan, it is difficult without a credit card to rent cars. I feel like it's almost impossible, but it can be difficult. So the good news or the bad news is usually within a month or two from filing bankruptcy, you're going to see your mailbox is going to get full of credit card advertisements, applications. The interest rates are not good, but they will qualify you for a credit card. It's just usually the terms aren't great early on. So you should plan on all credit cards being thrown out. So, Amboy says, what's the new law that's happening in September? So the legislature just passed a new statute. It's a new exemption as it relates to certain portions, particularly child tax credits related to tax refunds. And so in the past, basically, if you were getting a tax refund, most of it would have to be turned over to the bankruptcy court for distribution to your creditors. Now they have changed it. So a good chunk of most people's tax refunds will not be subject to turnover to the bankruptcy court. Some of it still will be, but most of it will not. So that's a big thing, because that was one of the big areas where Arizona bankruptcy trustees would go after it. So, all right, we have here Borg386 saying, what if you stop paying your credit cards 6 months before you file? Now, I can tell you a lot of people, when they file bankruptcy, some of them haven't paid them in years. I mean, there's lawsuits and things like that are pending. So if you stop, and my advice typically to people is, once you make the decision, I am filing this bankruptcy, I've talked to a bankruptcy attorney, I know that I qualify for it, that we're going forward, there's no reason to continue to pay it. Not only that, if you pay a bunch of money to your credit cards within the 90 days prior to filing for bankruptcy, it's actually called a preferential payment. And the bankruptcy trustee in a Chapter 7 could actually go back to American Express or to Citibank and claw that money back. And so I always say, once you talk to an attorney, once you know that you qualify for a Chapter 7 or a Chapter 13 under the means test, I would not continue to pay it. It's wasted money. It's not going to help the credit score overall. And in fact, it may cause some problems with the credit card company, because they're going to have this trustee having them ask for some money back. So hopefully that's helpful. Unless there's any other questions, we might end up a little bit early tonight. But check, all these questions are great questions. Check back to the videos. I was just looking. I'm at 986 videos on my YouTube channel. If you have questions about bankruptcy, if you have questions about debt collection lawsuits, I have a ton of information there. I started doing these things like 13 years ago. I look totally different. I'm a younger man back then. Go check those out. There's a lot of good information there. If you're in the state of Arizona, again, check out I'll put the link in here one more time, where you can set up an appointment. You'll deal directly with me, and I can help point you in the right direction. But I appreciate everybody checking in tonight. Stay cool if you're in Arizona. This is the miserable time of year. We're going to make it. Appreciate y'all checking in, and I'll catch you next week.